My name is Mbetera Clarence, an associate at Makonjo Nyaberi and Company Advocates. Welcome to today's episode. Today's episode is actually sponsored by one of our clients who saw a video on the internet which depicted a person whose house being approached by a landlord who went ahead and took the doors out from his front door in order to compel him to pay the rent. Under Kenyan law, specifically that is the Landlord and Tenant, Shops, Hotels, Catering Establishments Act, Cap 301 of the laws of Kenya, a landlord is not supposed to evict a tenant from a controlled tenancy without following the proper procedure provided for under law. The Act itself protects tenants from arbitral eviction from the controlled tenancies in order to ensure that tenants' rights are actually respected. In order for a landlord to actually evict a tenant from his own premises, is actually required to follow the proper procedure provided for under the Act. Section 4.1 of the Landlord and Tenant, Shops, Hotels and Catering Establishments Act provides that a landlord is supposed to give a notice of 2 months notice to the tenant before he can proceed to any eviction proceedings. Furthermore, the prescribed form that is required to be used is found under Rule 4 of the regulations of the said Act. In a situation whereby the tenant who has been served with a notice is opposed to the said notice, he is supposed to actually move the Business Premises Rent Tribunal within a month from being served that notice, at least so that you actually have the time to proceed with the matter itself in court. In a situation whereby the landlord is actually not comfortable with how the tenant has actually received the notice, and is not in a situation whereby the tenant himself is not receptive of the said notice, then is actually given an opportunity to move the Business Premises Rent Tribunal through a reference, or he can actually file a suit before the Environment and Land Court seeking to evict the tenant from that premises. In a situation whereby you want to evict a tenant without any court orders, the landlord has to be very careful because there are civil liabilities which arise from such situation, and also criminal sanctions which may arise from such a situation. It's actually better if the landlord actually moves the court correctly before using self-help means in order to actually remove the tenant premises itself. In the tribunal case of Eunice Baraka and Jared Yugi, that is a BPRT case number 4 of 2025, the court indicated that if a landlord fails to follow the proper procedure, actually any eviction process that arises from his actions won't be valid. In that particular case, the court actually gave the tenant quiet possession of the said premises, owing to the fact that the landlord had not served a proper notice and had not given clear reasons as to why they want to evict the tenant. For further inquiries, you can call the number in the screen or visit us at our offices. We'll ensure we cater to your needs.